If I have a will, do I need a trust? If I have a trust, do I need a will? Yes and yes. Let's understand a little bit about a last will and testament. A last will and testament, even if legally valid, correctly executed, has all of the bells and whistles, that document has no force or effect until the maker of the will passes away. And then the will has to be taken to the surrogate's court and probated. What happens then? Well, probate is a court proceeding, and it takes time. In this post-COVID world, it's taking the better part of a year, and some places, some counties, well over a year. So you might want to have a trust instead. But this question was, if I had this last will and testament, do I need a trust? Even in the instance that you want to dispose of your property through a last will and testament, it may make sense to have a trust for the potential event of having an incapacity. So incapacity is when you can't make decisions for yourself and you need to rely on the assistance of another adult person. A trust can fill in the gaps in those instances. So if a person has the onset of dementia and they own a business, the trustee can continue to operate the business. If a person owns a property, a rental income, or a one family or a multifamily, the trustee can continue to operate, collect rent, prosecute evictions, sign leases. The trustee can take action on your behalf in the event of this incapacity. So that's why you might want to additionally have a trust. The converse of that, if you have a trust, do you need a will? Yes. I feel that it's a required document. Even when I do a trust for a person, revocable trust or irrevocable trust, when I do prepare a trust for a person, if it's properly executed, it's going to be properly executed if you do it with me. If you have that trust, I still require that you leave my office with a last will and testament. Why? You need that for any after obtained assets or anything that wasn't properly funded into the trust. Once you have a trust, it's a legal entity, it's a warehouse, it's a storage facility, it's a safe, it's a vault, it's a vehicle to hold your assets. If you never place an asset into the trust is not the caretaker of anything. That's why I suggest, and more than suggest, require and direct and hope and pray that you also get a will, so that in the event there was an asset that you owned, a brokerage account, a bank account, a piece of property, if it had never gone into the trust, I have the last will and testament take care of that. Also, in the unfortunate instance that you inherit property from someone that predeceases you and you don't have time or the wherewithal or the thought to fund that into your trust and it's now in your individual name, we'd also have I would want you to have the last will and testament in place just in case. And if you properly fund your trust and you never receive or obtain assets after the date of the trust or after you've funded your trust, then you will never need to use the last will and testament, but at least you have it. What I want to do is safeguard your life and your assets by giving you both documents. What do you do if you can't find the will? Received a call today from a person that was related to it. Sometimes in these videos I don't want to give away too much. Even though you don't know the person, I don't mention names. I mention nephew or niece, aunt or uncle, right? So sometimes I start the story in a fractured way because I'm trying not to reveal confidence. Circumstances are, a person passed away and the will couldn't be. I was contacted by a relative that believes and understands that a will was drawn up, leaving a piece of property to this individual. And the presumption is, in the law, it says, if you cannot produce the original will, the thought is that the maker of the will revoked it. They threw it out. They tore it up. So you have to produce the original will, and a will is not required to be recorded anywhere during the life of the person. This person called me and said, I understand there's a will. My relative told me that there was a will, but it can't be found. And this person believes that another relative went into the home, took the will, and destroyed it because it didn't provide any advantage to that person to produce the will. That person was not receiving the property. And if there was no will, that person's going to receive a share of the property. What to do? In that situation, supposed facts as related to me, you can't do anything. How do you prove a negative? How do you prove that there was a will and that the will said what you think it said and that it should be the document brought to the court? Could it have been that this relative did in fact make a will a number of years ago and then changed his mind? Well, that could be. That could be why the will wasn't discovered. Could it be that the relative wanted to make a will to say that and never did? Yeah, that could have happened too. If you have a person that has told you, I'm going to put you in my will, should do what you can to receive that will during their life or to have it placed in a safe location. I don't really always recommend a safe deposit box because of certain circumstances. That would have been a better place than, the sock drawer or the file cabinet, because someone that has a vested interest in not producing that will could take a mischievous action. Please safeguard your estate plan, will, or trust in a safe place. Give it to your executor. Make sure that that trusted person takes the appropriate steps at your passing or the passing of a loved one.